Okay, here is the mark where it is e-file has been made, e-filing பண்ணிருக்காங்க இந்த mark. Okay, first we'll go to the see what is the mark. So 24 nature is the mark which they intend to register. It is also filed as a label mark, that is device mark they used as. So label mark தான் இதுவும் போறாங்க, but the word is 24 nature. Okay, they also filed in case of class 29. So class 29 க்கு தான் இந்த லேபிளும் யூஸ் பண்றாங்க. You see, it's important concept is statement as to use of mark. They mentioned as proposed to be used, that is it's not used prior to this application, so it is going to be used thereafter. It's very very important. Then you also see the date of filing, it is very important. Okay, then you see, one second, as I say, they are going for a registration for a one category, so they are filing 4,500 rupees. That is one applicant, name and address, country, jurisdiction. So jurisdiction if it is a Delhi, so address for service, so nature of applicant, firm. Okay, இதில் பார்த்தீங்கன்னா legal status பார்த்தீங்கன்னா sole proprietorship firm. Then with respect to agent, so they mentioned the agent. Who is the agent filing this? In previous case we don't have the agent, but here we are saying agent. So the nature of agent பார்த்தீங்கன்னா he is an advocate, not a trademark attorney, they are a advocate. So with respect to trademark detail, it's a device. Trademark 24 nature, image description it's a label. Okay, the nature of language pathina it's English thaan adu vandu idula. Then class and goods of service, they mentioned class number 29. Statement to be used as a mark vandu proposed to be used. So this is the thing. So then the date is essential. Then we have the power of attorney. So power of attorney here it is stamped for 20. In case of e-filing jurisdiction with respect to Chennai, the power of attorney must be 100 rupees. So then you have the power of attorney model. This is mentioned in form M, which gives a model for a power of attorney which to be granted by the trademark owner or intended trademark owner to the agent or a advocate. So advocate andhalume we must get an power of attorney, not like in the case podriki vakalathu kedadi, we have to get the power of attorney authorizing the advocate to file this application on their behalf. Okay, so the address for communication also to be given by the advocate address. So the advocate address மட்டும் தான் எல்லா communication வரும், not to the party. Okay, இந்த filing பொறுத்த வரைக்கும் you need to have a digital signature in case of a e-filing. So this application is filed under e-file application. Okay, let's come to the another application. So this is also another application which is made for same 24 nature, but you see the logo is varying, the design is also varying, but still the word they are intended to register is both are 24 nature. Okay, you see the usage statement as to use of mark, it is also proposed to be used. Okay, so both the mark are now in proposed to be used. Okay, in such situation who can win means the person who applied earlier, the person who first filed the application is going to acquire the trademark, the other one has to lose. Suppose, say for example, this person filed the application on 6/1/2020, the other person filed on 10/12/2019. So this application is the prior one, so they are going to be able to get the trademark. But still before the trademark is granted, there could be chances of opposition from both the parties. This party can oppose the application of other party and this party can oppose application of this party. இதில் என்ன பார்த்தீங்கன்னா இதில் வந்து இது ரெண்டு கேஸ்லையுமே both are proposed to be used. If one of the trademark applicant, if they are using its prior use, ரொம்ப இதுக்கு முன்னாடி ரொம்ப யூஸ் பண்ணிட்டு இருக்காருன்னா, if he able to substantiate his prior use, then he can get the trademark. But along with that prior use மட்டும் சொன்னா மட்டும் பத்தாது, he must prove that that particular mark acquired brand value. So brand value means அந்த name வந்து at least advertisements கொடுத்துக்கப்பட்டது, it should be in newspapers or in a book or in a TV, whatever it may be. அந்த மாதிரி இருந்துச்சுன்னா you have to produce the invoice, and suppose if it's a printed material, you have to produce the advertisement page, date and time where it is published, everything should be there. If you make any pamphlets and all, so if you அந்த மாதிரிலாம் போட்டு இங்கே போட்டுருக்காங்கன்னா அதோட இன்வாய்ஸ் எல்லாமே என்க்ளோஸ் பண்ணணும். From the date when it is used, okay, how much reputation that particular mark has been attained. You all know about the Dabur case பார்த்துருக்கோம், they produce the invoice with respect to homemade, how it is impacted, how it is gained the goodwill சொல்றது they describe. Similarly prior use also essential, but that prior use have made an impact and acquired a goodwill, so that must be established either that must be established through an affidavit, also with respect to documentary proof on their claims. If the registry able to satisfy with the goodwill acquired by the particular mark, okay, even though both the persons are filing, even though the person filed second, if they are able to establish this very prior to use and they are having the acquired a goodwill, the second person, even the application has been made by the second person later, they can acquire the trademark. Okay, okay, since this application is made for a physical, actually they wrongly pay 10,000 rupees. Since they going for a only one class, they don't go for a two class, so they paid the excess fees. They might have applied for a 29 and class 30 or 31. Okay, so they might have go for a two class, but they wrongly paid the higher fee, because for one class 4,500 in case of electronic, 5,000 in case of a physical filing. I don't know whether it's updated to 10,000 or 2020. I will verify, because earlier time it is 4,500. I know whether it has been updated. I will verify and tell you. Okay, next we will go to the, this is notice of opposition. Okay, as I said earlier, both the parties are opposing each other application. So this is form TMO. Form A is application, form TMO is application, form TMM is the power of attorney. Okay, there are various forms available. You had verify the trademark rules where you having the all the form. Even you can find out the forms alone in the IP India website. Also you can find out that fees table. Okay, so here is the opposition, notice of opposition. It's also included fee, so you must pay a fee for a notice of opposition. Unless you do a fee for notice of opposition, your notice of opposition cannot be taken. Okay, so they are given what's the ground for opposition, which is mentioned separately. Okay, because this column is not will not provide a mini space, so they can have opposition separately. So here there is a power of attorney given by this opposition party to their attorney, because in the case of Puthurikum, this is the, they are doing the opposition, so they are granting their power to their agent to oppose the case. So this is the power of attorney. Then we'll come to the form TMO, that is the ground. Okay, now they are saying that 24 nature versus 24, so both are opposition. Okay, then we are the party. Then they are going for a, what's the ground for opposition? Okay, they say why that application should not be accepted, why should you have been rejected. Okay, they are telling the thing. Okay, they are saying that the duration of use, stage mark, everything they are describing. But to my knowledge, this case, the opposition still, it is till now the mark is not granted. So my thing is, the person who applied earlier, they are going to get the mark, the other person going to lose the mark, because both of them don't have the evidence at all for its previous use. Simply they are having many pleading at all, but both in the both application they are saying that proposed to be used. So then automatically the first person who applied also only going to get the mark, since they are not filed any since they have not filed any evidence to prove their claim. Okay, so I will show the thing. So this is the opposition. This is the additional evidence. You see, they have not decided to adduce additional evidence by of affidavit. Okay, they don't have the evidence. Okay, just they only go with the statement and all. They don't have any document to support their claim. So இதான் ரெண்டு கேஸ்க்குமே அப்படி தான், they don't have any document to support. Both the party opposing each other trademark. Okay, but the matter is now still pending due to the COVID intervention. Thereafter, to my knowledge, the first person who applied is going to get the mark.